Reddit lawyers. What's the worst, wait, you did what moment you've lived through? Story 1. Ugh, this one still haunts me, in a way that makes my spine tingle every time someone claims their back is unusable. I spent hours building a solid case that my client was completely, utterly incapacitated. Severe back injury, couldn't sit in a chair, couldn't lift a cup of coffee without wincing. The man entered court like he was auditioning for the lead in The Crucifixion, a one-man mime. He paced, he stood with a grimace, he winced dramatically every time he blinked too hard. He made Quasimodo look ergonomic. And to be fair, I believed him. I defended him, zealously. That's my job. Then, opposing counsel calmly introduced a representative from the Department of Environmental Conservation. I assumed it was some kind of procedural detour. It was not. This man opened a file and proceeded to hand the court detailed logs of my client's hunting trips. Multiple entries. He had climbed into a tree stand in freezing temperatures at 4 a.m. and sat for hours. He had not only shot several deer, but dressed and hauled the carcasses out solo like a budget-season Rambo. They even had trail cam photos. He was grinning, kneeling, posing with antlers. One photo had him squatting. I didn't even try to rebut. I just sat down. The judge didn't need to say anything. The look said it all. Really? Tree stands? My client later told me, yeah, but adrenaline makes the pain go away. Sure, buddy, so does perjury. Let's just say that case ended with one less deer and one more hole in my professional dignity. Story 2. In-house now, but back in law school, I interned for a judge in our Court of Common Pleas, and I'll never forget this one case. A guy gets a ride from two young women in their early 20s, offering to pay cash for a lift from the mall to a nearby gas station. Sounds simple, right? Well, he gets in the back seat and casually lets them know he has a pellet gun that looks like a real handgun. His story and all the paperwork, he just pulled it out to show them. No threats, nothing aggressive, just showing off a fake piece. Fast forward to trial. He chooses to testify. Under cross, the prosecutor starts asking about the gun, how he handled it, what exactly happened. And this guy, apparently feeling like he's clarifying things, says something along the lines of, "I never said it wasn't a real handgun. I held it to her temple and told her I'd shoot if she didn't shut up. But I didn't mean it." Dead silence in the courtroom. Even the prosecutor blinked a few times like he'd misheard. The jury didn't take long. They were out and back so fast we thought maybe someone forgot their phone. Nope. Verdict delivered. No surprises. Moral of the story? If you're going to testify, especially in a criminal case, maybe don't admit to holding a weapon to someone's head. Story 3. I had a client charged with shooting and paralyzing victim. He was ID'd by a woman in the house that knew him, but the witness was potentially biased. Client says he wants to fight the case. We then discuss whether it should proceed time waived or time not waived. The difference is how quickly the case is set for trial. Time not waived means the trial is set within 60 days. Time waived means the trial can start in more than 60 days. The importance was that my client told me he was not at the scene. I stressed the importance of being honest and that everything is confidential. He again said he was not at the scene. I told him we could get cell phone records to confirm that his phone was not at the scene of the crime at the time of the shooting. And if we could show that it was active, meaning he was using it, it could help cement his alibi. I also said, but if you were at the scene, we should set this time not waived so the DA can't get your cell phone records. Client says to set it time waived and get the records. So, several months and a lot of work later, the cell phone records literally show him at the fucking crime scene at the time of the shooting. It also leads to more evidence more directly linking him to the shooting. The records also managed to implicate his friend as being involved. It took the case from being borderline to a slam dunk for the DA. It's even more ridiculous than this, but it's kinda off topic.
Story 4. One of my former clients was charged with shooting and paralyzing a man inside a house. He was identified by someone who knew him personally, but we had good reason to believe that witness might be biased. That gave us just enough room to consider a viable defense if and only if my client's story held up. So we're in early strategy talks, and I ask whether he wants to proceed time not waived, which fast-tracks the trial within 60 days, or time waived, which gives us more time to prepare, but also gives the DA more time to gather evidence. He tells me flat out, I wasn't there. I stress, as I always do, that our conversations are confidential, but that honesty is critical. He doubles down, not at the scene. So I suggest, okay, if that's true, we should subpoena me your cell phone records. If your phone was in another area and active at the time of the shooting, that helps your alibi. Then I give the reverse warning. But if you were there, the DA could use these records against you. In that case, we should push for a fast trial before they can get them. He looks me in the eye and says, time waived. Let's get the records. Months of legal work and discovery later, cell phone pings place him directly at the scene, at the exact time of the shooting. Not only that, but the data ties in his friend as well. Texts, calls, and tower locations that help the DA draw a detailed timeline. What was borderline circumstantial at first became a case so airtight I could practically hear the prosecution celebrating through the walls. All of it, because he told me to get the evidence that buried him. Story 5. Client walks into my office, new wife in tow, both of them locked in over a $5,000 judgment owed to his ex. Court orders mediation. Ex-wife isn't budging, she wants her $5,000. Client says he can't pay. Mediation's going nowhere. Then new wife steps in with a grand romantic gesture. Take my wedding ring. She says it's worth more than $5,000. He told her so himself. Let the ex sell it, pawn it, whatever. Just end this. Ex-wife agrees, on one condition, appraisal. 2 weeks later, I get a call from opposing counsel. Deal's off. Why? Because the ring was a $95 cubic zirconia. I bring it to my client, show him the appraisal. He shrugs and says, yeah, I knew that was going to happen. I stare at him, stunned. You knew? Oh yeah, but what was I supposed to do? Tell my wife I gave her a fake ring? I say, how about, no, my love, that ring is a symbol of our bond, and there's no way I'm giving it to my ex. I'll find another way to pay. He pauses, thinks about it, nods. Yeah, he says, that probably would have worked. Story 6. One of the more memorable cases I dealt with involved a motorcycle accident victim. Injured, yes, but not severely. CCTV footage confirmed they were clearly not at fault, so liability wasn't an issue. But they saw this as their golden ticket. They claimed permanent disability, couldn't walk properly, chronic pain, PTSD, couldn't possibly ever work again. What they forgot to mention to their own lawyer, and what we dug up, was that they had been working manual labor full-time, posted videos of themselves riding motorcycles again, and proudly shared footage of a bungee jump on social media. We sent over a neatly edited video compilation of all three to their legal team. Let's just say the multi-million-pound settlement they were expecting evaporated instantly, and they were lucky their next ride wasn't in a prison van. Story 7. It started like a routine special education case. The mother had been battling with the school district over services for her son. We pushed for independent evaluations, and sure enough, the results backed her up. He needed more support than the local school could provide. We arranged for a transfer to a better-equipped school nearby. Stronger programs, solid transit access, extracurriculars he actually looked forward to. So far, so good. Then she shows up to enroll him, and the school says there's a problem with the paperwork. No big deal, I think. Probably just a missing transfer form. I grab a full packet and head down in person to sort it out. But it wasn't a missing form. They tell me, not his legal name. She's not his legal mother. Cue silence. Turns out, 12 years earlier, she and her husband had taken in her best friend's baby.
The biological mom was about to go to prison on drug trafficking charges and had asked her friend to raise him for now. They signed a piece of notebook paper. That was it. No court orders, no custody filings, not even guardianship. For 12 years, they'd navigated school enrollment, medical care, everything under a false last name, using assumed parentage, and no one ever questioned it. It only came to light when the new school's enrollment system began auto-checking Social Security numbers across federal databases. Once we confirmed the truth, I had to act fast. The boy couldn't be enrolled until legal custody was sorted, and the school wouldn't budge. I leaned on a homeless youth provision in the education code to keep him from missing more school than he already had. Thankfully, that worked. Meanwhile, I reached out to the biological parents who, yes, were still alive, still in legal trouble, and to their credit, consented to an adoption. So, 12 years later, the couple who'd raised him finally became, in the eyes of the law, his real parents. But I still ask myself, how did no one catch this for over a decade? SMH. Story 8. Told from the attorney's point of view. I filed a bankruptcy for a client. Pretty standard stuff. A few weeks later, they called me upset. Said a payday lender was still contacting them, and worse, had pulled money directly from their bank account. That's a major violation. Once a bankruptcy is filed, creditors are legally barred from collecting. It's not a gray area. If true, we had grounds for sanctions. It was Monday. I knew the motion had to be filed by Friday to meet procedural deadlines. But the best practice is to give the creditor a chance to fix things first. I started with polite calls to the local store, then the national office. No one returned my messages. Each day, I updated my client, increasingly frustrated. By Friday, I was at my limit. I got a low-level rep on the phone and said firmly, "I need someone to call me back within the hour. Otherwise, I'm filing for sanctions." I even recited my time spent, enough to justify thousands of dollars in penalties if we won. Finally, a manager called back. Polite, professional, and dropped a bomb. Turns out, my client had taken out the payday loan after the bankruptcy was filed. I felt like the air had been knocked out of me. The client later admitted they knew the debt wasn't covered, but thought the lawyer would go away if they threw a lawyer at them. And that's mild, honestly. You'd be amazed how often people file bankruptcy and just forget to mention things like boats, second homes, cash stashes. The law is clear. Full, honest disclosure is non-negotiable. But somehow people still believe they can bluff the federal court system. This one didn't cost me the case, but it definitely cost me a weekend I'll never get back. Story 9. Told from the lawyer's point of view. I had a client in a family law matter, and we were mid-hearing. I'm standing there in court, passionately arguing that being a father is the most important thing in the world to my client. He lives for his child, prioritizes parenthood above all else, all the usual, genuinely believing it too. And then, from the other side of the courtroom, his ex chimes in, "Well, he never sees his other children." I paused, blinked, looked at my client. "I'm sorry, other children?" It was the first I was hearing of it, in front of the judge, while making the devoted father argument. Look, clients leave out things all the time. They get embarrassed. They think, if I don't bring it up, maybe no one else will. But this is a courtroom, not a confessional. Secrets don't stay secret here. If you're my client, I need to know everything. Even if you spent every Saturday night doing blow in a latex onesie at a basement rave, it's better I hear it from you than from your ex on the stand. I've heard worse. We all have. What we care about isn't whether it's messy, it's whether we're prepared. Don't make us find out in front of the judge. Story 10. I was representing a man accused of sexually assaulting the young daughter of his girlfriend, who, to complicate things further, was still married to another man. The case hinged on DNA evidence. There were no fluids, just trace skin cells. The profile wasn't an exact match, but it included my client among the possibilities. So we were staring down a battle over whether his DNA had any legitimate reason to be in that household. We went through every detail, every version of events, every possible defense, and for weeks he insisted there was no explanation for his DNA being there outside of casual contact. Then, just before trial, he finally told me, through an interpreter, that the woman's son, the child everyone believed was her husband's, was probably his. My client and the mother had been in a secret affair for over 5 years. That one sentence changed everything. Because if that boy was his biological son, it meant his DNA should be present in the home. And suddenly, the partial DNA match wasn't incriminating. It was explainable. Reasonable doubt started to look a lot more reasonable. I wish I could say this kind of last-minute reveal was rare. But the truth is, when there's a language barrier, stigma, or shame involved, vital details often stay buried until the very edge of disaster. Sometimes the hardest part of defending a client isn't the evidence. It's getting the full truth in time to use it.
My client was charged with being a convicted felon in possession of a handgun. Pretty straightforward charge, at least on paper. She had a 30-year-old theft conviction, and now she was riding shotgun in a car that had just been in a literal shootout on the interstate. Middle of the night, rural county, her car riddled with bullet holes, and where did they pull in? The state trooper post. Can't make that up. Now, the driver wasn't a felon, and weirdly, the state police didn't seem interested in figuring out who the other shooters were, even though this all started right up the road in their jurisdiction. Honestly, it looked like a drug deal gone wrong, but none of that really mattered for her charge. It was simple. Convicted felon, gun equals prison time. Still, she had a defense. No prints on the gun, no video, no eyewitnesses pointing to her firing it. And I'd met with her several times. We had a game plan. She stuck to her story. I was prepping for trial. Then, 2 weeks out, in passing, she mentions a talk with a state trooper at the post right after the incident. No big deal, just a little conversation. My stomach dropped. I checked discovery again. Nothing. So I filed a motion to compel any recordings. Turns out the prosecution had been sitting on an interview the entire time. Classic move from that office. Shady, unethical, and, sadly, expected. I get the video. 4 minutes in. 4. She flat out tells the trooper, "Yes, I knew the gun was in the car, and yes, I was the one shooting it." That was it. Every defense we'd built collapsed in an instant. We met the next day. I laid it all out for her. No games, no spin, just the cold truth. She took the deal. 5 years, minimum sentence. Could have been worse, but it didn't have to be this way. Lesson: tell your lawyer everything. We can fight a lot of things. Surprises from your own mouth in a hidden recording? Not one of them. Story 12. Told from the lawyer's perspective. I was handling a complex environmental permit case for a client. Standard stuff at first. They had secured their permit from the city level, but of course, the neighbors weren't thrilled. Big industrial operation next door, trucks in and out all day. It wasn't exactly blending in. The neighbors appealed. They threw a laundry list of objections our way, but most of the legal ones we were able to deflect. The 2 sticking points were, 1, the technical drawings were vague in a few spots, and 2, a noise study had been ordered but wasn't completed yet. Manageable. Then came the state-level site inspection. It was planned, but no one informed our firm, so we weren't there. Client decided to handle it himself, along with his architect. Bold move. The next day, the state calls us. Turns out that while poking around, the inspectors noticed something off about the plumbing. Specifically, that it looked nothing like what was shown in the plans. So they ask, where does the wastewater go? And the architect, God bless him, just casually says, "Oh, it drains straight into the little stream out back." The state officials blinked, took notes, left. My client calls me later, voice hesitant. "So, is that bad?"
Spoiler, yes. Yes, that's catastrophically bad. This was not just a minor oversight. According to the original permit and every subsequent update over the past 20 years, this company was supposed to have oil-water separators, collection tanks, proper drainage systems, the whole suite. Because their operations involved potential contamination, fluid leakage from machines, runoff from the car park, etc., they were heavily regulated. All of that was assumed to already exist and be in full working order. And now, in the middle of an active appeal, when legally you're not allowed to modify your application, they've essentially confessed to dumping wastewater into a stream for decades. There was no coming back from that. Not during this permit phase, not while under scrutiny. I had to sit my client down and explain that not only had they sabotaged their own case, they may have opened themselves up to environmental violations, fines, and, if the neighbors really wanted blood, a criminal investigation. Then I asked the question I should have asked from the start. Is there anything else we need to know? There was a long pause. Then, define anything. Moral of the story? Never, never let your client attend a regulatory inspection without counsel. And always, always ask about the plumbing. Story 13, told from the lawyer's perspective. The moment your client drops a bombshell while on the witness stand is the kind of experience that takes years off your life. There I was, in the middle of a routine custody hearing. My client, absolutely stunning, professionally polished, and honestly one of the most reliable clients I'd ever had, was testifying about her parenting, her work, her history. She had been at the same job for over 25 years, raised a child with special needs practically single-handedly, never missed a meeting, answered every email, and showed up early to court. A dream client. Then, unprompted, she says, "Well, I do have a little bit of a drug problem." I froze. So did the judge. The courtroom went silent. She continued, cheerfully, "Yeah, I've been using meth daily for a few years now, so I'll definitely fail the drug test." My mouth physically opened. I may have blinked in Morse code for help. To this day, I've never encountered anyone like her. Truly high-functioning despite a daily meth habit. But here's the part that made my soul leave my body. If she had told me this even the night before, we could have strategized, preemptively addressed it, built context, shown steps towards recovery. But learning about it for the first time in the middle of sworn testimony? Nothing you can do in that moment except hold on and pray the judge has coffee and compassion. Here's the takeaway. Tell your lawyer everything, especially the ugly stuff. We don't judge, we prep, and we can't protect you from what we don't know.
Story 15. This one's a little different. Not a train wreck, not a disaster. Actually, it turned out to be one of the most unexpectedly heartening cases I've had. I represent people trying to obtain or protect professional licenses, nurses, realtors, contractors, the whole range. So one day, I get a call from a man applying for a nursing license. Second career, wants to do good in the world. There's just one hiccup. He had been previously charged with first-degree murder. Not manslaughter, not a bar fight gone too far, straight-up murder. He pled to a lesser charge, but the details weren't pretty. Something involving a drug deal gone wrong. You can imagine how excited a nursing board would be to hand over a license to someone with that on their record. We prepare hard for the hearing. Since the facts were damaging and not really disputable, our entire case was going to hinge on the idea that he was a changed man. That he'd owned his mistakes, done his time, and was now trying to give back to society as a nurse. That strategy can work if it's sincere and consistent. Morning of the hearing, he's running late. I've got some time to kill, so just out of curiosity, I start digging through court records on his old case, expecting maybe a footnote, maybe nothing useful at all. Instead, I strike gold.
Turns out there was an appellate decision involving his co-defendants, 4 of them, who did go to trial. And that decision included pages of trial testimony. Each co-defendant had a different story about what happened. Who had the gun, who pulled the trigger, who panicked. It was all over the place. Except for 2 facts. 1, my client had been brought in last minute as muscle, a big guy who was just supposed to stand there and look intimidating. No one told him there were guns involved. No one told him it was even a drug deal. His role was minimal, possibly unknowing. 2, and this is the kicker, all 4 co-defendants agreed on this. When someone pulled a gun, my client turned around and ran. He sprinted out of there before the first shot was fired. So, not only was he not the aggressor, he fled at the first sign of danger. When he finally arrived, I asked why on earth he hadn't told me this. And he says, a little sheepishly, "I was embarrassed. I didn't want to admit I ran away. I was supposed to be the tough guy." I almost laughed. That was the best fact we had. That new info changed everything. We adjusted the entire argument. Showed that even back then, he wasn't someone who gravitated toward violence. He literally ran from it. He was scared and he got out. And in the years since, he'd become someone who dedicated his life to helping others. The board gave him his license. Years later, I still think about that one. He's a nurse now. By every account, a great one. And it's a reminder, sometimes people really do turn their lives around. They just need a shot. Story 16. That's a classic case of tell your lawyer everything, and tell them early. Here's the real problem. Once cash vanishes, especially cash that never touched a bank, it's almost impossible to prove it existed, let alone who took it. No paper trail, no account statements, just word against word. And judges hate murky money issues in divorce cases. In this case, the missing suitcase meant weeks of forensic work, filing emergency motions, trying to subpoena security footage, text messages, and reconstruct timelines, all because neither spouse trusted banks. It ended up costing her thousands more in legal fees than what a basic disclosure would have avoided. Moral of the story? If you're hiding money under the bed and getting divorced, stop. Put it somewhere traceable and tell your attorney immediately. Otherwise, it's just a magic trick where $100,000 disappears and your legal budget along with it.
Story 17. That right there is the perfect example of how one detail, even unrelated to the accident, can wreck a multi-million-dollar case. From a legal standpoint, the defendant was still at fault. The meth came after the accident. But once you're in front of a jury stacked with highly educated professionals, all it takes is one defense attorney saying, "Ladies and gentlemen, can we really trust his word?" And the whole case collapses under credibility. He didn't lose because of the accident. He lost because the jurors wouldn't believe his suffering when they saw a guy doing meth while claiming his life was destroyed. The sad part? If he'd been honest from the start, his attorneys could have planned for it, limited evidence, adjusted strategy, maybe even front-footed it as a sign of his mental health spiral post-trauma. Instead, it stayed hidden until the worst possible moment. And that's why it settled for far less than it could have. Lesson? In litigation, your worst secrets don't stay buried. They just get priced into the deal. Story 18? That is brutal, not just emotionally, but legally. In immigration court, credibility is everything, especially when relief like cancellation of removal hinges entirely on the discretion of the judge. They don't need hard proof beyond a reasonable doubt, just a reason to believe your client. And what should have been the strongest part of their case, a child with a rare medical condition, instead looked like a desperate last-minute Hail Mary. The irony? That condition could have easily tipped the case in their favor if disclosed early. Medical records, testimony from doctors, documentation of costs, travel, and stress on the family, it would have built a rock-solid hardship narrative. But by hiding what they thought was damaging,
They blew up the very thing that might have saved them. Moral of the story? Never rely on Cousin Juan who knows the system. Rely on your attorney and tell them everything, especially the stuff you're scared to say. Because what you don't say will almost always do more damage than what you do.
I worked in family law for a while. I'm now in personal injury, but one case really stuck with me. I was a law clerk at the time, assisting a family law attorney, and we took on a client who had been a stay-at-home dad to 6 children while his wife worked full-time, often overtime. They lived on a sort of family farm, and by all accounts, their life seemed incredibly wholesome. The oldest child was about 13 and wanted to show cows at competitions. The youngest was just 2. From the outside, they were the kind of family you'd expect to see on a butter commercial, rural, humble, close-knit. But then, out of nowhere, the dad came to us seeking a divorce and custody. Up to that point, he'd been representing himself and things had already gotten messy. His wife had kicked him out of the house, he said, after threatening to call the police and falsely claim he was abusing her. Not wanting to risk it, he left and moved into a small apartment. Now he was struggling to prove to the court that he could adequately care for all 6 kids in such a limited space. The guardian ad litem, child advocate, didn't believe he had the ability to provide for the kids, especially since he hadn't worked for over a decade. But then he dropped what he thought was a bombshell. His wife had left all 6 children alone at a public event in town for an entire day while she went to work, including the 2-year-old. He was furious and wanted to use this to get full custody. According to him, she dropped them off early in the morning and didn't come back until hours after her shift ended. Anything could have happened, he told us. We were preparing to present this as the smoking gun in court. Before the hearing, we met with the judge and opposing counsel in chambers to discuss the facts, and that's when things fell apart. Because the truth was not what our client had told us. Turns out, the dad's desire for a divorce wasn't as sudden as he made it sound. While his wife was busting her butt working long shifts to support their large family, he had started an online relationship with another stay-at-home parent, a married woman with several kids of her own. He was planning to leave his wife and marry this other woman. The reason he was kicked out wasn't because of false abuse accusations. His wife had discovered all the evidence of his affair and, understandably, lost it. She did call the police, but only said he might have a gun, not that he was abusive. And that whole "she abandoned the kids" story? He knew about it in advance. In fact, he encouraged it. She had to work that day and let him know the plan. He didn't step in to help, even though he was available and had no job. He thought it would look bad for her. We were shown the text messages in court, him telling her, "I can't believe you've left them there. This is going to look so bad for you." His strategy was clear. Let his wife do something questionable, don't intervene, then use it against her in court. But it gets worse. He'd been draining their joint bank account, not to support his kids, but to spend money on his new partner and her kids. Fancy dinners, clothes, day trips, all for them. Meanwhile, his own children were eating spaghetti on repeat. And then came the manipulation. He tried to coerce his wife into giving him money, saying he had pictures of their children's journals, pages where the kids had supposedly written about her abuse, making them eat vegetables, making them do homework, and if she didn't give him what he wanted, he'd use them in court. He also asked for spousal support, which he was legally entitled to, but when we told him that if he got remarried to his affair partner, he'd lose that support, he broke down in tears about how unfair that was. Unfair? We were standing in a courtroom bonfire of your own bullshit, and you want to talk about fairness? My internship ended before the case wrapped, but the attorney I worked under kept me posted. Spoiler, things did not improve for him.
Story 20. My client had a no-contact order in place with his ex-girlfriend. One day, he got a call from an unknown number. Picked up, no one answered, so he hung up and instinctively dialed 69 to see who it was. Surprise, it was her. She immediately called the police and reported him for violating the no-contact order. So we show up in court for the hearing. I actually felt like we had a strong defense. He didn't initiate the contact, and 69ing an unknown number is hardly intentional contact when you don't even know who called. While he was in the restroom, 2 police officers came over, saw the name on my case folder, and suddenly got very interested. When my client returned a few minutes later, they walked over and arrested him. Turns out he had an outstanding warrant for armed robbery. I was floored. I got a continuance for the no-contact violation case, but things quickly spiraled downhill. His car was parked in a garage nearby. It got impounded, and he couldn't get it out because he was now in custody. Worse yet, I couldn't get him transported from jail to court for his pending no-contact hearing because that particular city had a messy system. They didn't transport defendants from jail for unrelated misdemeanor cases unless someone jumped through a dozen bureaucratic hoops. Eventually, the public defender's office took over his cases. I moved out of that city not long after, but that day stuck with me. It was one hell of a bad day for my client. One minute we're prepping for a technical violation of a protective order, the next he's in handcuffs for armed robbery. And from that day on, I stopped putting client names on the outside of my case folders. You never know who's reading over your shoulder, or who's waiting for a name to match a warrant.
I was prosecuting what was supposed to be a straightforward assault and battery case. The version I had going into trial was simple. The baby daddy showed up, punched the mom's new boyfriend in the face, and left, taking the kid with him. Now, to be fair, the father had legal custody of the child, since the mother had tested positive for cocaine at the time of the baby's birth. At the time of the incident, the girlfriend, aka the baby mama, told the responding officers exactly that. Yes, her ex showed up, hit her new boyfriend, and left with the child. Pretty cut and dry. But between the incident and the trial, things changed. She and the new boyfriend broke up. And guess who she got back together with? Yup, the baby daddy. So now her story changed too. Suddenly, she was claiming it didn't happen, that her ex didn't hit anyone, that this whole thing was just a big misunderstanding. I wasn't buying it. She had already proven herself unreliable and clearly had a reason to protect her ex now. Meanwhile, the victim was still consistent. He was adamant that he'd been assaulted, and he had visible injuries to back it up. Bruising on his face, consistent with being punched. So I went ahead and put the case in front of a jury. Of course, the defense brings her up on the stand, and this is when the whole trial takes a sharp left turn. First, she drops the bombshell that she and the victim weren't just Netflix and chilling like she originally claimed to the police. No, they were actually doing cocaine together in the apartment and ignoring the baby, who was in another room. Apparently, the baby daddy knew this was where she usually got high, so when he saw her car parked outside, he came pounding on the door, demanding to see and take the child. But it gets even more ridiculous. Now she's saying that the victim, the man who reported the assault, actually hit himself in the face to make it look like the baby daddy had attacked him, that he staged the whole thing. And then, right there in the courtroom as she's telling this story, the so-called victim loses it. He starts literally punching himself in the head over and over again, yelling, "No, no, no," at the top of his lungs like a child having a meltdown. Picture one of those special needs kids you sometimes see at school who has to wear a helmet. It was that level of self-harm and loss of control. Then he storms out of the courtroom mid-testimony. So, yeah, the jury came back with a not guilty. And honestly, I got it. Here's one more for you. It was my very first hearing in front of a judge as an attorney, a Social Security disability appeal. My client had a legitimately devastating case. Years ago, he'd been crushed in a workplace accident. The entire left side of his body was mangled. Add to that a lifetime of mental health trauma, including PTSD from watching his own father shoot himself when he was a kid, and a long list of both physical and psychological issues. I was ready. Nervous, sure, but prepared. Of course, just my luck, I get assigned the worst judge the Social Security Administration has to offer. And I don't mean strict, I mean a capital J jackass.
For context, it's basically an unspoken rule in these hearings that you don't interrupt an attorney during their opening statement. You don't raise objections. You don't shout. You let them speak. Well, I'm about 3 sentences into my carefully prepared opening. I'm listing out my client's conditions, and the judge screams over me. "You forgot one! What about the drug abuse disorder? When was the last time your client did heroin?" I froze for half a second, glared at my client, took a breath, and calmly said, "Well, Your Honor, I didn't mention that, similar to how I didn't mention his pre-diabetes and seasonal allergies. It's not relevant to his ability to work, as he hasn't used in several years. Additionally, he admitted he used drugs to cope with mental health disorders, which he has since taken much better control over through consistent counseling." And let me tell you, I was damn proud of that answer. The judge backed off. My client won the case. I called to give him the good news, only to have his girlfriend answer and tell me he wouldn't be available for a while. He was serving 36 months for stealing a car.